5 justices, led by Chief Justice Roberts, uphold President Trump's travel ban. They reject the argument that the ban violates federal law. There are 2 relevant federal laws. One says that the president can exclude whomever he wants based on group identity if that group threatens national security. Another law says that the president can't discriminate on the basis of religion in making immigration decisions. And these 5 justices said the president gets deference in national security and he only can't discriminate on the basis of religion in issuing visas, but he can draw distinctions when deciding which group poses a threat. And then there was and the significant thing is that the 2 liberal justices agreed with that there was no federal statutory ban to the travel ban, and even Justices Sotomayor and Ginsburg didn't press that point. So the entire court didn't focus on the possibility that the ban violated federal law. Instead, the dispute was about whether it violated the Establishment Clause of the First Amendment, which says Congress shall make no law establishing religion or prohibiting the free exercise thereof. 5 justices, led by Chief Justice Roberts, said, no, this was not religious discrimination because Congress picked these countries and found that they were dangerous. Not all of them are Muslim countries, and the president gets huge deference when it comes to immigration. 2 justices, Kagan and Breyer, said, we think there might be evidence of religious discrimination, but we're not sure. We're concerned that the waiver provisions are not being administered in an even-handed way, which would suggest that the national security reason is a pretext, and therefore we want to send it back to the lower courts to see how this is actually being administered. And 2 justices, led by Justice Sonia Sotomayor, wrote one of the most fiery and passionate dissenting opinions in recent memory, saying that this is an example of race-based discrimination and religious-based discrimination that will stand in ignominy along with the Korematsu decision, which upheld the Japanese internment. The court formally overturned that decision in the majority opinion, but Justice Sotomayor said that was a pallid concession since these stereotypes on the basis of religion unsupported by empirical evidence are just as harmful as those in Korematsu. And she also quoted extensively from the president's tweets which she said were infected at every stage with religious bias. So I've just tried to describe the 3 arguments. Nancy, discuss.
Well, there's so much to unpack. On the one hand, the decisions of the judges around the country on the travel ban cases were initially surprising. And they were surprising because this, in fact, is an area in which presidents have plenary power, which is to say, broad questions of exclusion and admission into the country. And all of the injunctions were weighing, where a judge had to weigh what was the likelihood of success, what was the public interest. And usually when a judge has wiggle room like that, there is massive deference to the executive. And what was interesting to me, and I wrote about this, was that, in fact, you didn't see that. And I wondered, from the lower court decisions, whether we were seeing sort of a new regime called judging in a time of Trump, when you defer to the executive because of the assumption that there has been a regular process, that agencies have looked at it, people have looked at facts, and it's been done in good faith in the area of the president's expertise. And that all of a sudden, coming out of these decisions was a sense that this is a different world. That deference may make sense before, but it doesn't make sense now. The 5 justices who decided the travel ban case represented a return to the old deference at all costs view here. And it effectively ignored the things that the president had said on the campaign trail, effectively ignored the provenance of the travel ban, which is to say the first one was so badly drawn that green card holders were excluded from the United States, a category as to which we had absolutely no authority to do. And it essentially took him how many months to come up with a rationale. And in other parts of the law, if the rationale seems to be a pretext, you say that. Instead, the 5 said, really return to very old-fashioned views. The president has plenary authority. This is good enough. What they said about why they were doing what they were doing was good enough. Then, along the lines of what you were just saying, which is that Breyer and Kagan tried to masterpiece cake it.
Yes.
For want of a better, masterpiece cake it.
Masterpiece, like that as a new term.
Right, it's a verb.
Explain.
A masterpiece cake was We're not going to address whether this was in fact religious discrimination to refuse to make a cake, discrimination against same-sex couples to refuse to make a cake in a same-sex marriage. We're going to essentially remand it for a fuller factual record of who said what. Interestingly enough, a fuller factual record about intent to discriminate against the baker whose religious freedom was at stake. Actually, when I heard about Masterpiece Case, I thought, oh, that would be interesting. That may suggest that the travel ban would go in that direction as well. This is a court looking under, peeking under the coverlet to see whether there was intentional discrimination, even if the act was on its face fair and neutral.